may reserve up to 5 minutes for rebuttal if you're the appellant and wish to reserve any time. I'm keeping the clock to let me know. That helps me out in letting you know what the passage of time is. Please don't use the names of any children or, I should say minors, or victims, as we are recording this oral argument and will be posted on this court's YouTube channel. I want to apologize that we're getting a later start this morning than it was scheduled for. I apologize to all counsel. We've read the briefs, we're ready to proceed with more.
Thank you. Good morning. Attorney Corinne Hoover 6 on behalf of appellant, the mother in this case. This matter stems from a reallocation proceeding of parental rights and responsibilities that was originally tried to a magistrate, issued in a magistrate's decision, and then was ultimately affirmed by the trial court in February of 2022. Mother appealed that decision on two major grounds. One is a finding of contempt against her for willful and continual denial of father's parenting time, and secondarily, the allocation of custody to father and the termination of the parties' prior shared parenting plan based in large part on that continual and willful denial of parenting time. Procedurally, this case is certainly an oddity because the contempt finding was determined by this court to not be a final appealable order due to the attorney's fees derivative from that contempt still proceeding in the trial court. So we are here today on the parenting-related matters not related to the contempt proceeding, which really pertains to mother's assignment of error 4 and 5 only. The crux of mother's argument is that there were two applicable court orders in place at the time of this proceeding, which the trial court erred in considering in finding that mother continually and willfully denied parenting time and switching custody from the shared parenting termination to sole custody to father. The first of those orders is the party's original shared parenting plan dated May 20th, 2010. Although after that plan was filed with the court, there were some slight modifications to that through agreed judgment entries thereafter. The bulk of that plan remained unchanged and was unchanged at the time of this proceeding. Interestingly, the shared parenting plan dealt specifically with the event that the child had opposition to parenting time with one parent. The plan specifically indicated that if a child indicates strong opposition to being with the other parent, it's the responsibility of each parent to appropriately deal with the situation by calmly talking to the child as to the child's reasons and to work with the other parent to do what's in the child's best interest, particularly to avoid confrontation or unpleasant scene. In this case, mother did just that. This case began when mother learned from the child that father had a drug problem. After that, on mother's own volition, discovered that the child was correct, that father was facing felony charges in relation to prescription drug matters as a medical professional, taking those drugs from work, and was in fact in a rehabilitation center. Father did not share this information with mother. Mother learned it from the child. Mother then initiated this action to reallocate parental rights and responsibilities based on that and out of concern of safety of the child. Sometime thereafter, several months thereafter, the child started expressing great opposition to parenting time, including jumping from the vehicle of father when father picked him up for parenting time. Because of this...
Excuse me, was that father or was it the grandparents that were transporting?
I'm sorry, I don't believe... It very well could have been the grandparents that were transporting. I'm sorry, I don't recall.
I just wanted to make sure.
Yes, thank you. This case is going on 5 years now, and so you probably know the facts more than I do.
I just remember it was the fact.
From reading. It may very well have been the grandparents, but yes, grandparents or somebody who's picking up the child to exercise parenting time with father, and the child jumped from the vehicle. Thereafter, mother's position was that in following the mandates of the shared parenting plan, that she had to do everything within the child's best interest to address the child's opposition to this parenting time. Mother enrolled the child in counseling and sought the attention of the court. And sometime thereafter, the parties actually reached an agreement dated September 12, 2018, that, and at this time, the child had refused parenting time with father for approximately a month. That time the agreed judgment entry was instituted, the child was in counseling with his individual counselor. the child was also then going to start family counseling with a court-appointed counselor, Ms. McMillan. And at that point in time, the agreed entry indicated that all parties would follow the therapeutic directives of the counselor. Mother's position is that she then entered into family counseling with the child and father for an entire year period of time. And ultimately, that was successful. The child was restored with his relationship with father, began exercising normal parenting time with father, and was restored to that appropriate parent-child relationship, despite the circumstances that began this proceeding. In going back to the shared parenting plan, when mother is addressing this issue, she again followed that mandate of acting in the child's best interest, talking to the child calmly, doing anything that she could in the child's best interest. Father did as well. They all entered into the shared family counseling arrangement, which again was ultimately successful. Furthermore, this agreed judgment entry, which indicated that the parties would follow the therapeutic directives of the counselor, is extremely important because both counselors ended up testifying in this proceeding. The family counselor specifically testified the child should not have been forced to go with father, but instead that the parties should move at the child's pace. That counselor also testified that nothing that she observed indicated that mother was coaching the child or when mother was interfering in the relationship, but that the parties should all work together to restore parenting time based on the child's pace. The child's individual counselor likewise testified that the goal of her counseling was to restore the child to a meaningful, appropriate relationship with father and take into consideration his concerns. The guardian ad litem in this proceeding ultimately did recommend that the parties' shared parenting plan be terminated and that father be named the sole custodian. In the guardian ad litem's testimony, she testified that the crux of her recommendation was mother's willful and continual denial of parenting time. The guardian ad litem came into this proceeding, however, after Ms. McMillan had already testified. This proceeding's litigation lasted approximately 3 years. So Ms. McMillan testified on the first day, and the guardian was appointed sometime after, perhaps even a year later. The guardian in her testimony, however, indicated that she was unable to speak with the counselor, the family counselor, when she became involved, and that if the family counselor had recommended the child not be forced to go to parenting time, that would change her recommendation. The record is clear that the family counselor indicated the child should not be forced to go. Also interestingly, fact-wise, is that father himself acquiesced to going at the child's pace. In our exhibits, we had an exhibit of the parties were communicating via the application Our Family Wizard, and father in there states, nobody is forcing Riker to speed up. We're going at, the child's pace. In doing that, father is acknowledging that the counselor's recommendation is to go at the child's pace, and then father disingenuously turns around and ultimately files a contempt proceeding seeking to hold mom responsible, although he himself participated in that family counseling where the recommendations were the child should not be forced to go until or unless he was ready. Certainly the best interest factors for the court's consideration here is multiple factors: interrelationships and interactions between the child and the various homes, child's comfort, the homeschool communities raised, other factors such as abuse and domestic violence factors, and all of those. The magistrate's decision and ultimately the judge's decision did examine those best interest factors. However, in looking at those, essentially at best, it seemed to be that the triers of fact thought that mom and dad were really even on most of them. But again, the tipping point was mother's continual and willful denial of parenting time. So therefore, if mother did not continually and willfully deny parenting time, then was the decision an abuse of discretion?
Counsel,
Yes.
just looking at this, a question comes to my mind based on one of the things you just said, and that is if mother is not in contempt, that was a tipping point. We can't look at the contempt yet. So should we be looking at the merits of this period?
Your Honor, that's a great question, and I struggle with this as well. If this court were to determine that this is not right for appeal because the contempt has not caught up, I will tell you, we would have no opposition to that. It is a complete oddity, and it's difficult to argue with half of the case here and half of the case still there. Certainly, I'd imagine at the time of filing the appeal, the trial court would have made the determination on attorney's fees, we would appeal that, and it would essentially catch up and ultimately be combined. That hasn't happened, that matter is still proceeding and under objection at the trial court level right now. I would reserve the remaining time for rebuttal. Thank you.
Thank you, Councilor.
Good morning. May it please the court, my name is Mary Randazzo, and I'm here representing the appellee, who is the father in this particular matter. I'm here to answer questions, ultimately. This is a voluminous case, as are many highly contested custody cases. I would draw the court's attention back to the actual evidence that was presented.
Okay, counsel, why don't I start with the question I asked of your opposing counsel? How are we to decide the merits of who should have custody of this child if the main foundation of the change of custody was the mother's lack of sticking to the parenting time and willfully not allowing her out of visitation?
Thank you. So the standard for a show cause for contempt is different than the standard for an allocation of parental rights and responsibilities. There are multiple factors that are considered by a court when weighing which parent or what the allocation of parental rights and responsibilities would look like. Certainly, the appellant would like to draw attention directly to, was there contempt? Did my client actually evade her responsibilities under a court order? That is a separate and distinct matter. The burden in that particular matter is to show there was a court order, that the order was violated, and that there was no justified defense. That's separate and distinct from the weighing of multiple best interest factors in an allocation of parental rights and responsibilities. In this particular case, what is very important is the factor that asks in a shared parenting context whether or not the parties can actually manage information and make decisions cooperatively and together. Ultimately, the court said, no, they cannot. So leaving aside the fact that there were over 100 days that were presented, that mom had denied parenting time, and all the facts and circumstances that led up to that, the ultimate decision of the court is saying these two individuals cannot cooperate, cannot operate as a shared parenting plan. Therefore, that's terminated. When we move then to the best interest factors, if I may, there are other factors to consider. Parenting time is just one element. The factor that is being drawn attention to is the interference with parental rights and responsibilities or parenting time under a shared parenting plan. In this particular case, the court spent time actually looking at the interference with father's parental rights. He was an equal custodian under a shared parenting plan.
Okay, and before you go into the best interest,
Yes.
I'm going to lose focus of the question. So if you don't mind, I'm going to go back to my question. And that is, I understand that there are different burdens of proof, different, obviously it has to be intentional, willful with a contempt. But didn't the court, just in its findings, say that this was an intentional, even aside from the contempt, and relied on that finding in regard to the fact that they couldn't co-parent together and shared parenting?
I agree with you.
Okay, so
I
if
agree
we
with you.
rule that we affirm, haven't we in essence then affirmed or at least collaterally stopped some of the arguments in regard to the contempt at least?
I would disagree. I believe that they are still unique in the fact that the interference with, or in this particular case, the denial, whether it's intentional for consideration for contempt purposes, the court did consider it to be intentional for the purposes of not having shared parenting anymore and allocating custody, therefore, to father individually.
Okay, and that's what I'm getting at. How could we have conflicting decisions on those? Once we make a determination in this regarding whether mom intentionally did not provide parenting time to father, okay, and that was one reason why there should not be shared parenting anymore, how in the world could we ever determine under a contempt that she is not
perspective, or for our perspective that we would argue, is that the willful conduct can lead to a contempt finding, whereas the intention, it did not happen. In fact, the parties would stipulate it did not happen. She did not send the child for the parenting time. So the court then has to ascertain whether it's under a best interest factor, or if it rises to the higher level of a contempt finding, whether or not they want to take action based on that. You can have a change in custody without there being a contempt finding. That could happen. This court could say that in balancing and looking at the court did not abuse its discretion in looking at all of these factors and considering that the child did not go. Mom did not uphold her part of her responsibilities, and that therefore that is partial evidence, partial within the weight of all of the factors to say these two cannot cooperate together.
Okay, so let's say that we would rule that, that the court, that was against the weight of the evidence that the court, that mom did not withhold parenting time, okay?
Mhm.
Whether willful or not willful. Wouldn't that decision by us then take care of the contempt as well? If she didn't withhold parenting time,
It very well may, based on the way that you are describing. If this court were to look at one specific factor in consideration of all of the weighing, and saying that the court did not weigh this particular factor properly, or that it's this court's independent look at the evidence to say that, oh, mom didn't withhold the child. That is within the discretion of this court to look at it from the antithesis of your original question.
okay, let me just ask this as follow-up then too. Do you agree that we have to look at, to determine the appeal that's in front of us now on assignment error 4 and 5, that we have to determine whether or not mother willfully withheld?
No, I do not believe that it has to be a willful finding. A willful finding is under a contempt standard. It is not under the standard of weighing of the best interest factors.
Okay, how about an intentional withholding?
The intention is by the effect. And so this is a young child at the beginning of this case and through the end over a period of 3 years. The facts themselves will lay out before the court the way the facts will lay out before the court. As to intention, the child did not go. And so father was present. There are experts, or strike that, not experts, but neutral individuals who looked at exactly that question. There are facts and circumstances that have been amplified in appellant's presentation to the court, which are not accurate. This case actually, although it was filed in March of 2018, father, what we're saying is the impetus for this case, or the child informing mother, there is evidence in the records which shows that that is not accurate. Those are just not accurate recitations of the facts. There is evidence before the court that demonstrates that in August, the first time the child decided that the child did not want to participate was literally in the same week that mother said, I don't want you to have your last week of summer vacation. This is all in the evidence for the court to look at, and that's what the trial court looked at. The timing just did not smell good to the court. That when mother started to amplify and say, I don't want you to have this, all of a sudden the child said, I don't want to do that. When father said, this child's on seizure medication, and the seizure medication has a known byproduct of, or a known cause of anxiety and advanced reactions in children, I want to have him have a second look at that. Mother said, no, I'm canceling that appointment, you can't do that. When father would say, hey, my family's coming into town, you yourself, mother, have said in writing that if family's there, it's okay. And then the correspondence comes from counsel saying the child's not going to go. So the child didn't go. Mother did not do her part to ensure that the child went. The court draws together mom's own words in all of this correspondence, a lot of our family wizard messages. The court draws together all of that as the trier of fact to say these are so closely connected, to say that mother's behavior and child's behavior, that there was an influence to the child that resulted in the child not going. So that is, in essence, the intention. Now, whether that becomes willful or mother could not remove the enmeshment of herself from the child, that may come under the contempt level. But as far as weighing that within the statutory factors, that in balance with the outcome, in balance with this spiraling of events, mom doesn't want him to go, the child doesn't go, child's not going, dad, your only recourse is to get into family counseling. Dad says, I'll do whatever it's going to take. We do whatever it's going to take. We're participating. Well, family counseling says, I'm listening to mom. You'll read in the magistrate's decision and on by the trial court. I'm listening to mom. I'm listening to the child. We need you all to be on the same page before the child will go. So as long as mom says no, or the child says no, the child does not go. It became a snowball effect of over 100 days.
Counsel, I know the record is voluminous, but my understanding is that it does not include the in-camera interview of the child. Is that correct?
I did not transfer any file that was an in-camera interview of the child, so I would not know whether or not that was there. Thank you. If there's no other questions by the remaining members of the panel, we believe that when weighing the evidence, the trial court properly determined that termination of the shared parenting plan is in the best interest of this child. And thereafter, the court considered weighing the abilities of each of these parents, which parent would be better suited to allocate sole custody. And that the court properly thereafter allocated sole custody and residential parent status to father, based on a weighing of all of the factors herein. Thank you.
Thank you, counsel.
Let me ask you before you start.
Yeah.
Are we missing it, or is the in-camera, was the in-camera interview requested to be part of the record? Okay,
I
you
have
said it's very
no
voluminous.
idea. I honestly cannot even recall
Okay.
if there was an in-camera interview conducted. The child was appointed a guardian ad litem. The guardian ad litem testified, gave a report. Written report was certainly part of the record. I cannot recall. I would disagree with counsel in regards to the factors here of that the contempt finding and the best interest factoring are different for really two major reasons. The best interest factors, which are in 310904, F1s very specifically, indicates there are two factors really on point to this. Factor F is parent more likely to honor and facilitate court-approved parenting time rights, which counsel did mention. But however, there is another factor, and factor I is if either of the parents has continually and willfully denied the parenting time rights of the others. So this continual and willful aspect is very much a part of the best interest factors. It's not a separate determination. Although certainly the law is different as in regards to what a finding has to be made for a contempt and a finding of best interest, that continual and willful is part of both. And so therefore I do agree with the line of questioning is that it is difficult to ask this court to make a determination on this without having essentially the entire case before it on the contempt. And certainly it's difficult to argue because so much of it is based on that. The trial court, in both the magistrate and the ultimate judgment decision, indicated several times that the two aspects were so interwoven with one another, it was impossible to look at them separately. And I think that's something that it's in the judgment entry, it's in the magistrate's decision. It will ultimately catch up to this court in regards to the attorney's fees aspect, but there have been multiple judgment entries from the court indicating that these mother's entire defense to contempt is also her defense as to why she shouldn't have been deprived custody. I do agree that certainly the record probably reflects substantially that these parents are unable to really co-parent very effectively. So the ultimate termination of the shared parenting plan, my client, her position would be that they can still manage that. However, with the evidence, I understand counsel's position is that the court really probably just by nature of the proactive litigation had in front of it the determination of can we do this with both parents or is it one or the other. But the tipping factor that weighed in favor of father was that mother continually and willfully denied those parenting time rights. And if that is overturned by this court, then that would reopen the entire custody matter as well. Finally, I did not address previously our assignment of error number 5, which was our assignment that the trial court abuses discretion by overruling mother's objections without taking an independent review. Our argument really is limited to that with consideration of this agreed judgment entry from September of 2018, which indicated that the parties were to follow the therapeutic directives of the family counselor and the child's counselor. That was mother's argument at trial court. It was at the trial. It was certainly the crux of her argument in the objection, is that if this agreed judgment entry did not exist, we would be in a completely different position. But this agreed judgment entry, which was agreed by the parties after this proceeding began to follow the therapeutic directives of the counselor, and then the counselor ultimately testified that no one should force this child to go to parenting time, we believe that that's determinative. When the trial court reviewed mother's objection, there was again no mention of this agreed judgment entry and the ultimate effect on the case. The magistrate previously had not mentioned it, and therefore our argument is that had the court conducted an independent review and really drawn attention to an applicable court order in place, that the entire proceeding very well could have changed.
When did this recording of the counseling session come in? Was it during the cross-examination of the counselor, or?
Yes, it was, Sandra McMillan was the first witness, I believe, to testify, and that's what it came in as far as cross-examination on.
Thank you.
Thank you. The panel has no further questions. I would rest. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We wish a written decision, which will be mailed to all parties to this appeal, as well as posted on the Supreme Court website. Our next oral